Former President's legal counsel arguing before the Pietermaritzburg High Court yesterday that Zuma would be prejudiced if he were to be arrested today, and that the court does have jurisdiction to rule on the application to halt the arrest of the former president. That's despite the arrest order having been issued by the highest court in the land. So how does this work? Luckily, we have someone who's a lot more savvy when it comes to legal issues than I am, legal expert from Toit Attorneys, Marius Du Toit. Marius, good morning to you. And there's a lot I'd like to unpack. We just don't have the time to go through everything. I'd like to talk about the prejudiced element of the argument. But first, how is it possible, a little bit I know about law, how is it possible that a high court does have jurisdiction to potentially stop an order or reverse an order of the constitutional court in this country? Has it ever even happened?
Well, let me put it to you this way. I think predominantly when you bring an application, you'll bring it to the court that granted the order. However, in this instance, the court, the police that's going to execute the order will be the police in KwaZulu-Natal. And the arrest will be affected in KwaZulu-Natal. And I think that's the reason why they decided to bring the application in the Pietermaritzburg High Court, being the court that will have authority over the arrest itself. Of course, there are many grounds upon which a person would be able to establish jurisdiction in court. And in this instance, I would believe that there would be nothing untoward with bringing the application in Pietermaritzburg. Having said that, of course, it's still an open question as to whether, at the end of the day, this order will in fact be rescinded by the Constitutional Court. And that makes it very difficult because at the end of the day, when the Pietermaritzburg High Court considers it, they're not the court considering whether the rescission or the application to set aside the judgment or the order or to the committal to prison by the Constitutional Court. They don't have the authority to rule on that because that's before another court. And that makes it very, very difficult. But let me put it to you this way. You know, when you go to the Supreme Court of Appeal and you've got a matter in the High Court Pretoria, let's say it originated in the High Court Pretoria, even though the matter is in the Supreme Court of Appeal, you can bring your application for bail and you have to bring it before the High Court in Pretoria. So there's nothing uncommon about the fact that one court considers a matter that's before another court, provided that court is vested with jurisdiction in the matter itself.
So how would the legal play work if, for example, and obviously we don't know yet, I am speculating, I'm happy to admit that I am speculating here. What happens if the High Court in Pietermaritzburg does agree with the Jacob Zuma legal team on this? What can the state then do? Does the state then go back to the Constitutional Court to overrule the overruling of the High Court in Pietermaritzburg? You can see why us non-legal people are failing to understand how this works.
Yes, it seems on face value that we are all in drift sand at this stage. But let me put it to you this way. I think the Pietermaritzburg High Court can essentially only consider the issue of whether the arrest should be affected or not. Okay. They are not able to pronounce on the validity of the order, keeping in mind that the Concord is the highest court of the land. No lower court can really make a decision that binds the Concord. So it will always be subject to the Concord making a ruling. So all this court can say is that, listen, I believe that the arrest should be stayed pending the finalization of the ruling by the Concord. Or the court can say, no, I believe that the arrest should be effected immediately because there's nothing that suspends the arrest. To just put it in another context for you, if an accused, for argument's sake, now we don't have an accused in this matter here, but if an accused is a person that's committed to prison, then the only way the order will be suspended is if the court grants him bail pending that process. Now, in this instance here, if we would apply a similar process to what we have here, then you would have to say that this court would have to give an order to say, well, listen, I'm not going to allow the arrest to be affected pending the Concord's decision on whether the order should be set aside or whether the court should consider new facts, being, of course, the issue of COVID in prison. And that could, of course, have a bearing on it.
Can we talk SAPs for a moment, Marius, if you don't mind? Just help us understand. So, as of the end of today, my understanding is that the former president should still be arrested based on what the Concourt has ruled on. The police minister is saying he's waiting for the outcome of exactly the court case you and I are talking about. So, has the police minister done the right thing in this case?
Well, let's firstly look at it from this perspective. I think any court order that's not been cancelled or rescinded or suspended has to be executed. That's the principle. So if we apply that to the facts here, the order has not been suspended. No court has given an order to say the Concourt's order should not be executed upon Mr. Zuma. So first and foremost, the arrest should take place. However, that is always subject to a court's review or subject to a court's consideration of the facts. Now, in this instance, we have a court order from the Concourt, and then we have an application pending before the Pietermaritzburg High Court, specifically pertaining to the arrest. So there is a process in place that says that, listen, we want this order to be suspended, or we want you at least to give us grace until the Concourt makes a ruling on the point. So in that vein, you have to say, whilst the matter is before a court, one would expect that court to say, well, you know, we're not going to execute the order pending this resolution. And to apply it to another set of facts, you know, I recently had a matter where the SCA was considering whether our client should be granted special leave to appeal. And we applied for bail. And in essence, he had to be committed to prison as well. But because we brought the application, the state did not execute the arrest. And as a result, when the judgment came out 2 weeks later, the client was allowed to remain on bail. So if I apply that to Mr. Zuma's matter, I would expect that whilst there's an application before the court, whilst there's a process that's in place, one would expect the arrest not to be effected pending that resolution, because then you have the scenario where if he has to be arrested, now he's arrested and Friday he's released, and it just becomes an administrative and a judicial nightmare. So I would expect, whilst the matter is currently before a court and a court has not pronounced on it, it would only be wise by the minister to perhaps say, let's hold back, let's wait for the ruling on Friday morning, and then we'll execute the warrant, depending on what that court says.
Marius, thank you, because actually it's now beginning to make sense from the legal side. Just before I say goodbye to you, last 30 seconds or so, just on the argument of prejudice, age and health concerns for the former president, how much water does that hold?
Well, let me put it to you this way. I think the difficulty for Mr. Zuma is the fact that he was, in my view, in willful default when it came to the Concourt's ruling. So I would not expect his argument to hold water, because you can't have your cake and eat it. You can't expect to say, listen, I'm not going to partake in this process, but then at the end of the day, I now want you to reconsider the facts. So I think there's not a good prospect in that regard. But having the question that you raised pertains specifically to COVID and his age. I'm quite sure the Concourt would have considered his age. Everybody understands that he's 78 years old. COVID, I'm not so sure was considered. I got a bail granted for a person specifically on that ground. And I would imagine that the Concourt would definitely consider it, because we live in unprecedented times. But the difficulty still remains that if you have to go back, you have to say, listen, you were in willful default, you elected not to take part of the process, and because you didn't take part in the process of the Concourt, I'm not prepared to listen to you now. And that's what I would expect the Concourt to say.
Well, I appreciate your time. A lot of clarity for us this morning. Really appreciate that. Legal expert Marius Du Toit from Du Toit Attorneys, making sense, I think, as to especially on the issue around the police minister, not necessarily disagreeing with the way it should be done, waiting for the court order to come through and the decision on Friday, as opposed to arresting Jacob Zuma, having him released on Friday, and then waiting for the Concourt decision. It does get administratively messy. My thanks to Marius Du Toit.
All right.